Thank you everyone who's joined us so far. I am just watching our participants list slowly increase as people join us. So we'll leave it just a couple of minutes for everyone to be able to join the webinar. Well, I think we might just start, and hopefully other people will be able to join us in the next few minutes. So thank you everyone for being here, and we are delighted to be here to launch the latest report from the Bar Human Rights Committee. This is our most recent trial observation report from Guantanamo Bay relating to the trial of the 9/11 accused, including Khalid Sheikh Mohammed and others. We are delighted to have a really interesting panel for you to hear from today. They are Zimran Samuel, who is Executive Committee member of the Bar Human Rights Committee and the author of this report. James Connell, who is a defence lawyer representing one of the accused in the trial. Colleen Kelly, who is a bereaved family member of one of the victims of 9/11, and Alex McGrath, who was also a trial observer, and I'll introduce them all properly in a minute. So for those who don't know, the Bar Human Rights Committee of England and Wales is the international human rights arm of the Bar here in the UK, well, in England and Wales specifically. We're an independent and international arm of the Bar of England and Wales. We're not associated with the Bar Council, but we collaborate with it. And our work is to protect the rights of advocates, judges, and human rights defenders around the world. We work to defend the rule of law and increase protections and heightened standards of human rights, the right to a fair trial, and the rights of victims as well in those processes. And we do that through observations like this, fact-finding missions, amicus briefs, and trainings, as well as statements of concern. In 2019, we were the only UK-based organisation to be granted official observer status for the ongoing trials at Camp Justice in Guantanamo. And we've observed 3 cases now, as well as submitting, well, I say 3 cases. We've observed the 9/11 hearings twice, and we've observed the al-Nashiri case as well. And we've submitted amicus curiae briefs to the military court and the Court of Military Commissions Review, which is the appeal court from the trial process, which we're waiting to hear the outcome on in relation to use of evidence obtained by torture. We continue to highlight and express concerns about the way that the process is running, and this is another opportunity to do so. So I'm going to hand over to Zimran first to introduce his report to us, and then we're going to move on to a panel discussion from our other speakers in relation to certain aspects of both those findings that Zimran made and broader issues around the trial process and how it affects its participants. So I'm just going to introduce our speakers to you now, and then I'll hand over to Zimran. Zimran Samuel then has extensive experience in care proceedings in England and Wales, and he specialises in international children's law, including relocation, abduction, radicalisation cases, forced marriage and female genital mutilation. He's authored a book in relation to FGM law and practice, and before coming to the bar, he worked at the Office of Legal Affairs at the UN headquarters in New York and regularly attended UN General Assembly and Security Council meetings. He's, as I said, an executive committee member of BHRC and has a strong interest in public international law and international human rights issues. James Cannell is Learned Counsel, the Military Commission's defence organisation. He represents Ammar al-Baluchi in the 9/11 proceedings. Learned Counsel means, I think, you can clarify for us later, James, but senior counsel in that matter. He's worked in this role for more than 12 years, advocating for his clients' rights and challenging the legality and fairness of the process. It's 20 years or more in criminal defence, human rights, freedom of information and music law. And I'm fascinated by the fact that he's pursuing a master's in music at Berklee College of Music, which seems like an excellent diversion from this kind of work. Colleen Kelly is the co-founder of 9/11 Families for Peaceful Tomorrows, which is an organisation that emerged from a small group of family members of those killed during the attacks on September the 11th. The group aims to turn their grief into action for peace. Colleen is the sister of William Hill Kelly Jr., who died in Tower 1 on 9/11. She's also a family nurse practitioner and specialises in adolescent medicine in the Bronx, New York, and serves as chair of the Rule of Law Committee for Peaceful Tomorrows, and also holds a master's degree in international relations from the City College of New York. And Colleen, I know so much time has passed, but I still extend our commiserations for the loss of your brother. And as we know, over 2,000 other people who lost their lives on that day. Finally, Alex McGrath is at the University of Michigan Law School, where he is obviously studying law in his second year. He was also an observer at the time that Zimran went to see the 9/11 trials, hearings, pre-trial hearings, and he was there for the National Institute for Military Justice. He studied political science at Yale and worked also as a researcher for the Right Honourable David Lammy MP, which you will all know now, well, those of us who are from the UK will know is our current Foreign Secretary. After graduating from that degree there, his research interests include legal philosophy, civil procedure, meta-ethics, whatever that is, and comparative constitutional law. So those are our speakers, and I should have introduced myself as well. So I'm a vice chair, co-vice chair of the Human Rights Committee, and a barrister at Garden Court Chambers here in the UK. And I attended the one of the pre-trial hearings of the al-Nashiri trial process a couple of years ago. So Zimran, can I hand over to you to introduce your report to us, please?
Thank you very much, Jodie. It's a huge pleasure, guys, to speak to you. I'm really thankful to all the speakers who have agreed to join us for this session. And thank you to everyone who's taken time out to join us from different parts of the world to listen and ask questions at the end. On the 12th of March this year, the US ambassador to the UN stated that the US is taking serious efforts to transfer detainees out of Guantanamo and that it is taking transparent efforts to close the facility. Of course, the detention and trial regime at the US naval base remains open, and it remains shrouded in secrecy and hugely controversial internationally. Now, I was at the naval base earlier this year for the 49th set of pre-trial hearings in the case of, as Jody said, USA versus Khalid Sheikh Mohammed et al., the trial of 5 men for the range of crimes relating to 9/11 attacks. Now, we say 5 men. In fact, I think there are currently 4 men, as last year one of them was found not competent to stand trial because of the treatment he has suffered. The military commission has not yet set a trial date for the remaining 9/11, the 4 remaining 9/11 defendants. Now, I just want to start it off by saying that I was in Guantanamo Bay for a short period of time. I was away for this monitoring visit for 10 days, and 7 of those 10 days were spent at the military base. So my report is but a snapshot in a very long and complicated process. I do, however, want to speak about my experiences, my key observations, and the findings that my report comes to. I traveled firstly from Joint Base Andrews in Washington, D.C. To the military base. And we stayed in a place that Jody mentioned earlier, Camp Justice, which is actually where the hearings themselves take place, at a modified command center, which has been converted into a courtroom. I was one of 5 NGO observers, Alex and Colleen, who were on the call, 2 of the others. And the NGO observers stay in a tent at Camp Justice. In fact, me and Alex shared a tent during our week at the base. And we were given an NGO work tent, a space to do our research and put together our thoughts. And a mechanism to ask questions formally of the military commission, and also informally. I remember on our very first night, the El Balochi team, led by James Connell, invited us for dinner. And that was a really, really great way to just get to know the lawyers informally and try and get an idea what was happening in the week ahead. So what was going on during the time I spent there? Well, the defense lawyers sought to suppress confessions that agents of the FBI had elicited from the detainees in early 2007, over a year after the men had been transferred to the base from various CIA black sites. Prosecutors argued that the detainees' statements were made voluntarily long after the enhanced interrogation techniques, the EITs, were used against them. This theory, I think James will correct me if I'm wrong, was termed fear extinction because it was contended that whatever interrogation and conditioning the detainees had initially faced, its effect had diminished or it had extinguished over the passage of time, particularly since the detainees had moved from site to site. The defense teams countered that the statements were made under the threat of continued torture. I should say these arguments aren't unique to this case. They were rehearsed in the Nashiri case, for which the BHRC, Jody said, did a amicus curiae brief. The first witness that we heard oral evidence from was a chap called Dr. James Mitchell. Dr. Mitchell was a psychologist hired by the CIA who took part in the interrogation of detainees and had designed many of the techniques that they'd faced. He gave evidence that the detainees were housed at 10 different CIA black sites over a period of some 4 years before they were transferred to Guantanamo Bay. He gave evidence about the EITs used against the detainees, including waterboarding, rectal feeding, repeatedly slamming the detainees' heads against the wall with little notice. I think he called that walling. Sleep deprivation, food deprivation, and many other techniques. These techniques were conducted in what he described as often an environment like a dungeon, and he acknowledged that the conditions themselves may have helped to overcome the detainees' resistance. During the report, and I go into much more detail, and I also talk about my own personal impression of this witness. In short, my view was, listening in, that his demeanor and responses were defensive and adversarial. He was often patronizing to the lawyers when he didn't like a question that he was asked. He reiterated his pride in his work and his strong support for the enhanced interrogation techniques. Often in cross-examination, Dr. Mitchell stated that anyone who wanted to understand the psychology behind his techniques better should buy a copy of his book. He gave evidence that the accused were videotaped 24 hours per day, and all the interrogations were in fact videotaped. Of course, we know now that the CIA destroyed all the videotapes before the Senate Select Committee on Intelligence began an investigation of the black sites. The next person who gave oral evidence in the time I was present was FBI Special Agent James Hodgson. The defense lawyers sought to establish a connection between his agency, the FBI, and the CIA in the early days after the capture of the detainees. Mr. Hodgson gave evidence that he was part of an operation called the Fan Mail Project, where he examined the detainees' incoming and outgoing mail to elicit intelligence information. My report goes into detail about how correspondence was used and potentially misused, in one incident potentially to fabricate confession. The court heard about Mr. Hodgson's role in facilitating requests from the defense teams for meetings with the CIA operatives who had actually conducted the torture. And that was quite uncomfortable listening at one point, because as I heard, the defense teams had been told categorically that none of those operatives were interested in speaking to them. And we heard evidence that at least one operative during one of the meetings said that he or she was open to the possibility of speaking to the defense. Mr. Hodgson was unwilling to answer the question on whether the government had been untruthful in its handling of this process. So, guys, that's some of the observations that are in this lengthy report, but ultimately the role of the BHRC in monitoring visits such as this is to examine where international law is applicable. Well, several issues of concern arise that indicate a significant level of concern in relation to international law and due process. I'm going to very briefly set out 5. Firstly, the potential application of the death penalty. Each of the charges faced by the defendants in this case carries the death penalty if convicted. The US has not ratified the second optional protocol to the ICCPR, which commits states parties to abolition. However, the US is bound by Article 6 of ICCPR, which prohibits the arbitrary deprivation of life. My report finds that in circumstances of this case, the conditions of detention and trial at the base do not adequately provide the defendants with those rights or safeguards, and any use of the death penalty in this case would amount to the arbitrary deprivation of life. I should also add that the BHRC remains opposed to the use of death penalty in all circumstances. Secondly, allegations of torture and ill treatment. The prohibition of torture is universally recognized in customary international law and enshrined in several international human rights instruments. Whilst we've known about the torture in this case now for some time, it was nevertheless concerning and harrowing and difficult to listen to some of the details in oral evidence and in its ongoing justification and the failure to impartially investigate the torture. And after all these years, it seemed that the prosecution was still trying to rely upon statements taken after extensive torture on the basis that they were conducted by clean teams. Thirdly, the presumption of innocence. The presumption of innocence is obviously a fundamental part of any functioning criminal justice system. My own impression was that the detainees at the base are generally considered to be treated as guilty. The system is very much stacked against them having a fair trial. And looking at the Military Commissions Act 2009, it's difficult to reconcile the presumption of innocence with the designation of the defendants as unprivileged enemy belligerents, something which is necessary in order for them to be under the jurisdiction of that court. Fourthly, trial without unreasonable delay. The pre-trial phase has taken an inordinate length of time. Families are still awaiting justice 23 years after these terrorist attacks. The military commission has not yet, as I said earlier, set a date for the 9/11 defendants. And there are obviously lots of reasons for the delays, but the sheer length and procedural history in this case is sufficient to give rise to fundamental concerns about the fairness of the conduct. Fifthly and lastly, the use of classified evidence. The overarching impression that I had of these proceedings is that there was a constant tug of war going on between the prosecution and defense, where the prosecution knew information that was withheld from the defense, and the defense had to, over time, try to prize out material in a drip fashion. I recall that the judge has this sort of red light that's next to him on the bench, which starts flashing every time something is mentioned which may breach national security, and then us observers have to very quickly leave the courtroom. And I recall during my last few moments in the very last day of observation, James Connell, who you're going to hear from after me, who represents Mr. Al-Balochi, highlighted his concern of the expansion of national security privilege gradually in this case. And I can imagine that it makes it very difficult for the defense to challenge the accuracy and probative value of material relied upon by the prosecution in these sorts of circumstances. So broadly speaking, those were my findings. My report endorses the views of the UN Special Rapporteur Fiona Nolan, who was in Guantanamo Bay last year. I think that was the first visit of its sort ever that was allowed. And the BHRC continues to recommend that the US close the detention facility at the naval base and make a renewed commitment to upholding international human rights law. And to conclude, my impression was that the process has been unfair, it remains unfair, and does little to achieve justice for the 9/11 victims. The whole setup of proceedings is bizarre and a fascinating cocktail of contradictions. Every single day I was reminded of something in relation to those contradictions, and perhaps we can come back to that and the other observers can comment on that. But the US flag flies over the base at Camp Justice, and everyone at the base stops once a day for the playing of the national anthem. And yet the application of the principles of the rule of law and human rights that the US rightly is so proud of is superficial here at best. My report ends with a short postscript because last month there was some significant news. It was announced on the 3rd of August that a plea deal had been reached with these defendants in the present case. The deal would reportedly have spared the defendants from the death penalty. However, the US Defense Secretary almost immediately ordered the agreement be revoked. So there would appear to be some level of significant executive involvement and interference in the deal that was reached. I recall Gary Sowards, who's the lead counsel for Khalid Sheikh Mohammed, commenting at the time. I am respectfully and profoundly disappointed, he said, that after all these years, the government has still not learned the lessons in this case, and that mischief results from disregarding due process and fair play. So that's all I have to say for now, guys. I'm grateful for all those who made the observational visit possible, to the US Department of Defense and the staff at the Pentagon who assisted me with the clearances I needed to do the monitoring visit. The US government doesn't have to agree to BHRC observers or any NGO observers coming to the base, and it does. And the ability of such legal observers to attend these hearings in person at the base is, to my mind, valuable for transparency. And I hope this report contributes to some of that. Thank you very much.
Thank you, Zimran. That's a really helpful whistle-stop tour through the things that you observed and findings which are unsurprisingly similar to the ones that we'd identified previously, but it builds upon that in demonstrating that the same issues continue to plague, for want of a better word, the process. So I want to turn now to our other speakers and the questions really that arise out of your report and presentation for us this evening. And perhaps the place to start is with that plea deal. So these are questions, I think, which perhaps James and Colleen can help us with the most in terms of what your impressions are about what happened there, because from the outside it was obvious that, and I think when I was last there myself, that the plea negotiations were continuing, so it'd been going on for quite some time, and appeared to have reached a conclusion, which I imagine, Colleen, there was some communication at least to victims' families about, if not input from you in that process. And to have a member of the executive come into that process and veto it seems utterly remarkable to me. Obviously, proceedings at Guantanamo take place within a military context and under specialised rules, but even so, it does seem remarkable. So, James, I don't know if you want to just go first to give us a little précis of what happened in your impression, then Colleen, please do feel free to follow up.
Sure. Thank you so much to BHRC for having us and for all your continuing contributions to the Military Commission's process. It's really helpful to have people who understand the way that human rights work throughout the world come and observe. As for myself, I can tell you that it's a sanity check because, first of all, it's good to know that other people think it's crazy too. But second of all, it's good to have an outside voice and view in case we start to get used to the crazy too much. So with respect to the plea negotiations started in earnest in March of 2022, proceeded for a long time until August of 2023, when there was a renewed media interest in the case, and our legislature, Congress, got involved and started making a lot of statements against the plea negotiations, not by people who necessarily had a very detailed understanding of what was happening down in Guantanamo or how long the process had been going on or how bogged down it is. And then there was a kind of a time off where after that happened with Congress, the President Biden issued his statements that he did not support the plea negotiations or particular elements of them. That there was a step back for a period of time, but then in July, there was a renewed effort on everyone's part to rejuvenate those plea negotiations, which culminated in 3 of the defendants signing a plea agreement, which happens to not include my client, but the other 3 remaining defendants signed plea agreements with the decision-making body for the Department of Defense, who was called the Convening Authority. And then the Secretary of Defense Austin, 2 days later, stepped in and, as a superior in the chain of command, decided that he was going to withdraw the power of the Convening Authority to enter plea negotiations and was going to withdraw from plea negotiations using his newfound power. Now, the thing that I want to observe is not only is that extraordinary and has never really happened before, but it's patently illegal under military justice principles, because as you might suspect, the chain of command frequently comes into play in military justice because everyone who gets in trouble in a military justice system has a superior, and everyone who convenes some kind of a court martial has a superior, and some of those superiors have different opinions. So since the 1880s in the United States, military justice has developed principles which protect subordinate commanders, like the Convening Authority, from interference from their superiors, who aren't allowed to change military justice simply because they simply have a different view. So what we're waiting for now is for some briefing to be finalized on these various issues of unlawful influence by a superior and the status of those pretrial agreements. It's our expectation that it's not likely that we will see any argument on that or decisions until November, but it's an issue that a lot of people are following closely, and we expect it to come up soon.
And Colleen, from your perspective, how did this interference play out for you and the other victims' families?
Well, thanks first for the invitation. I do agree with Jay that having outside, especially international observers come, it does keep us all from being desensitized to how irregular and how odd everything is that happens at Guantanamo. Once you're there a lot, it's easy just to feel, oh, this is just part of the norm, because irregularities happen almost daily there. So thanks for being there and witnessing in your own way the irregularities and reporting about those. Regarding the pretrial agreements and the negotiations, I just want to say for one moment, I am involved in a 9/11 family group, September 11th Families for Peaceful Tomorrows. And because I'm a family member, I not only am permitted to travel as a family member to Guantanamo to watch the proceedings, but also because our organization is an NGO with observer status, we can travel as an observer. So we have two options to witness the proceedings live at Guantanamo. Further, we have the option of going to family viewing sites that are set up on the East Coast of the United States, in New York and New Jersey and Massachusetts, where family members can go watch there. I can tell you that almost no one attends from the family viewing sites, because we are now in the 12th year, gosh, maybe the 12th year of pretrial hearings. So when something like this goes on, and you did mention this, Zim, in your introduction, when this length of time continues, it's not as though family members are not interested, or we don't care, or we've forgotten. It's the fact that it's 12 years later and we're not at trial yet. It's really defeating. And so there's many circumstances. So I'm saying this to tell you all that our organization is deeply committed to sending an observer or a family member to all of these hearings, primarily in person, but sometimes we watch it from afar on a 40-second time delay. We were notified back in, as Jay said, these negotiations started in earnest in March of 2022. And in May of 23, the prosecution teams notified family members that they were going on a listening tour. That's my word, not theirs. And that they were coming to various places, New York City, Boston, Washington, DC, I believe Florida, that might have been by Zoom. And they wanted to hear from family members. They wanted to update family members about the status of the pretrial hearings. And they also wanted to hear from family members' ideas. We had people present at all those meetings, except for the Zoom that happened. And it's a fact that less than 100 people were present at those meetings. Family members may have contacted the prosecution singularly, but at the official meetings, there was less than 100 family members present. So when you consider that nearly 3,000 people were killed on September 11th, you can see how this is a very small majority of input. We were told at that point that there were negotiations that were happening. That has also been reported widely in the New York Times and other publications. But I think that was a shock to some family members too, to hear that negotiating with the accused, negotiating with terrorists, it was hard for some family members to hear. And then, as we all saw in August, because of political opinion and members of Congress speaking out, that kind of all collapsed by September of last year, with official word from the administration that they were not seeking these agreements anymore. So then to this summer, so that was kind of on the back burner. This summer, some families were notified on a Wednesday, July 31st, by a phone call from the prosecution that an agreement had been reached. And I can tell you that was a moment for me personally that felt like I had worked for, and our organization had worked for over a decade to get to this moment. It was not the outcome that we had hoped for initially, but given all the irregularities, it was a chance at accountability, that someone was going to be held accountable for murdering nearly 3,000 people. And it was a chance for family members, per report, we have not seen a copy of the actual agreement, family members would have an opportunity to ask the accused questions. And our understanding is it would foreclose any path towards appeal. And to anyone who's been paying attention to these pretrials, having 12 years of pretrial hearings, you can only imagine if this continues to be a trial, and with all of the irregularities, or military commission, I should say, that appeal process, my kids will not be alive by the time that appeal process goes through. So for us, it was the best option of a lot of bad options. And we fully supported. To have Secretary Austin reverse that decision 2 days later, it was real emotional whiplash. And I think people have talked about this, in writing and whatnot. It felt like it was whiplash. And it's still unclear exactly how that came to be. There, as Jay will talk in depth, there will be, hopefully there will be some open arguments and open hearings about how that decision came to be, and basically whether that is legal or not. So it still feels yet again, exponentially yet again, that these hearings will continue ad infinitum. We don't know what's happening. So thank you for the opportunity to speak, and I look forward to questions about this as well.
Yeah, I can't imagine how frustrating this is from your perspective. When we talk about justice from both sides, that it needs a conclusion. And we're here 20 years on in this situation, that it just seems remarkable. James, I know you have to leave because you have to get to court. There are hearings ongoing at Guantanamo at the moment in this case. I just want to, before you go, if you could maybe, we've got a list of questions here, but I think what I want to try and take out of these, the essence of them really is, after such delay and irregularities, as Colleen describes them, from your perspective, how does that delay impact upon your ability to properly defend your client? And I suppose not just the delay, but also the final point that Zimran was making about the security clearances that's required in everything as you go along. How does this make your job harder than the average case, I guess, is the question, and how do you manage that, other than doing a degree in music?
Right. Thank you to Colleen and Zimran and everyone for all their input. And speaking of 52nd pretrial hearing in the 9/11 Commission. So at 1900 your time, I have to be back in court. Luckily, the court is very near me, so I'm very near the court, so that won't be a problem. We heard about the ongoing challenge to the use of evidence obtained by torture. We heard about the question of whether these pretrial agreements are enforceable, or whether they superior command influence has interfered with them. There's a third issue that is going on right now, has been a big focus of the last 15 months or so. And if your members came to Guantanamo anytime in the relatively near future, would probably hear this issue discussed. And that's the one that you talk about, which is in the United States, sometimes called classification privilege or national security privilege. And the significance is there are really two different obstacles that are posed by that. One is the obstacle to a public trial. And it came up today in court, for example, that something that we were allowed to ask in 2019, the government has changed the classification guidance, and now it can only be asked in closed session, which means that observers are denied the opportunity, and victim family members and media and everyone else are denied the opportunity of learning what's actually happening in the case. But perhaps even more shocking than that is, in this case, unlike any other case in United States history, the government has pioneered a thing that it is calling national security privilege, which is that some elements of the defense we are simply not allowed to present. Some witnesses we are not allowed to question. Some evidence we are not allowed to look into its provenance, and some topics that are of relevance to the defense and to the prosecution, of course, we're not allowed to inquire into at all. We hope early in the next year, depending on what happens, because next year we expect to have our 10th judge in the case because it's been going on so long. Once that judge has their feet under them, we expect to be presenting the legal arguments around this same question. And then finally, since you're talking about obstacles, before I go, I have to say that the number one obstacle in this case on a variety of levels is the United States decision to use torture as a method of investigation. And that has not just permeated the classification elements of the case, but it has severely damaged Mr. Al-Baluchi, our client, and others in a way that makes it very difficult for them to participate in their own defense. It's an issue that is with us every day when we meet with him, when we go to court. The torture is so absolutely prohibited in international law for a reason. And one of those many reasons is that it corrupts every justice system that it touches. I want to say thank you so much for having me. I'm sorry that I have to run off.
No, thank you so much, James. And that's a really important point to end on. We will continue that discussion with those important and powerful words. Thank you. And I look forward to talking to you again in future. Yeah, so that aspect is what really came across to me in the al-Nashiri case, and it does in this report of Zimran's as well. Alex, I'm going to bring you in shortly, but Khalid, just on that point, I suppose, how does it impact your journey towards justice to know and hear, particularly when we're going through these hearings about suppression of evidence, how these individuals were treated, and how that kind of infects your ability to get the answers that you need about what happened?
So since Jay just left, I'm going to repeat something that I believe I first heard him say. I know that I first heard him say it. These two things are true. It is true that nearly 3,000 people were murdered. And it is also true that men were horribly tortured while they were being detained. Both things are true. So anyone approaching this case has to kind of hold that dichotomy within their response. They're both facts. And that's difficult for many people. I understand the difficulty in that. I also know that torture is the reason that 9/11 families do not have accountability and we don't have justice. If those men were never tortured, we would not be where we are today. A trial would be done, a trial would be over with, and everything would be finished and there'd be some sense of completion and accountability. But the fact that the four, initially 5 men were tortured, that has brought us to this moment in time. I think it's very difficult for people to accept that sometimes. I've noticed recently, a few weeks ago, I said to someone of the word torture and then describing parts of the torture as being sodomized. And when that person heard the word sodomy, then it all clicked. Like, that happened to some of the detainees. Yes, some of the detainees were sodomized. So I don't know if it's in our culture here in America, we've become almost somewhat immune to the word torture. We saw it on this TV show 24 with Jack Bauer, whatever his name was. It feels like we're immune to what that means. But to sit in court and to hear the details of what happened, it's really, really difficult. It's difficult. I don't look at video from 9/11 because it's so difficult to watch murder happening. I also find it extremely difficult to hear about ways in which people were tortured. So torture has held up this trial.
I want to just tell you about an incident that happened, I think today or yesterday. What day is it? Tuesday. Yesterday, from Carol Rosenberg, who is a fantastic journalist who you all know well, who's been documenting what happens there since its inception, 2003. She couldn't be with us because she's there observing, but I did have a bit of a discussion with her this morning, our time, as to any thoughts and observations she wanted to give us. So she said initially she had some concerns about the observer process, and we'll come back to that, Alex and Zimran, on your views, and as well, Colleen, with your NGO hat on. But she said, yesterday, there was a terribly sad episode of new guards and contractors trying to force 9/11 families to hide behind a curtain over their objections. It went on, an ugly power struggle in the gallery. It was painful and a bit frightening to watch. It made clear how people who administer and guard the court don't really understand how a court should function. To explain to our attendees, the observer space in the court is effectively a gallery, and you observe through glass. You're not in the courtroom itself. You sit outside and you observe on a time delay, and you can't hear because it's 3 very strong triple panes of glass there. So you hear through an audio relay. But there is a curtain that separates that space in two, between where the families sit and where the observers sit, the other observers, the NGO observers sit. I don't know what your impression of that curtain is, Colleen, having sat on the other side of it, but I understand its purpose is to allow some privacy to the family members who may find the process particularly hard and don't want to be looked at by observers who are perhaps observing everything. But if a family member doesn't want to be behind that curtain because it makes them feel in any way, sorry, I'm hesitating because she's literally just emailed to say we have an emerging development, so I'm gonna have to see what that is. But yeah, if someone doesn't want that curtain closed for whatever reason, to have this sort of almost farcical set of rules where someone's saying, no, the curtain needs to be closed. I mean, how would that make you feel? And I think, Zimran, you can give us your example, which I'm sure, Alex, you'll recall as well, of a silly incident whilst you were there. But yeah, what are your impressions of that, Carol? Sorry, Colleen.
Yeah, I think there's two issues at play. One, Jay mentioned about the arbitrariness of rules and how rules change. So in 2012, when the court first started, there was no curtain that separated the families from the media and NGO observers. And in 2015, when I first went, there was also no curtain there. Then the curtain appeared. What happened yesterday, one of Peaceful Tomorrow's members is there as a family member, and we also have a person there as an NGO observer. So what happened yesterday, it's a new guard force, and the guard force rotates through every 11 months. So with a new guard force, there's often new rules and new understanding of rules. And the family members who were there, not just one family member, the family members who were there agreed that they did not want the curtain closed because they could not see the defendants who sit on the far left-hand part of the courtroom. So in agreement, they then opened the curtain because they wanted to see the defendants. And the guard came and shut it, and then this power struggle ensued. So it's really just, it feels very self-defeating to have, of course, the struggle is really about justice, but it gets played out in things like a curtain in a viewing area. It shouldn't be an issue at all. In federal courts, there is no curtain. My belief is that this is painful and sad and horrible to sit through. And if someone wants to view that sorrow and pain, I think that they should, to see how hard it is for family members still. So that's my viewpoint. I don't think it happens in any other court. I don't know that for sure. I'm not a lawyer, but it just seems another irregularity to have the curtain there in the first place.
Yeah, as I say, I assumed it was so that there was some privacy from the other observers. I'm sure that's what I was told. I didn't, having not sat there, I didn't realize that your view would be blocked of the defendants. So that's really interesting to know that might be its purpose, and to have that wish denied is ridiculous. Zimran, I think you recount an incident in the report of a ridiculous rule that you observed as well. I don't know if you want to update us on that bit.
Yeah, Jodie, it's just echoes what I was saying before, that the place is full of a cocktail of contradictions and arbitrary rules, and this is just something silly that happened, which actually reflects that wider picture. But I was sat on one of the trial observation days, and I think I was sitting next to Alex because we had pre-allocated seating, and we had the same regime happen that happens every morning, which is a police guard sits everybody down and said, look, the session's going to start. No one's allowed to doodle. No one's allowed to laugh. No one's allowed to fall asleep. And it's read out in a very sort of strict and somber way. And the same guard, probably within half an hour of echoing that command to all of us, slumped in his seat and fell asleep. And it did put a smile on a couple of people's faces, but there was a more serious side to it as well. In that the whole situation is full of these sorts of arbitrary rules and bizarre. It's a place that's synonymous with breaches of human rights, and at the same time, it's a normal place to walk around. There's a bowling alley, a cinema, a pub, a couple of restaurants. And I remember saying to Alex, who's going to speak after me, is that it rather felt like, I don't know if you guys have seen the movie The Truman Show. Somewhere, and you had the sort of impression of reality when actually it was all a very sort of made up bubble of fake reality.
Yeah. And I think the other thing from my perspective, and Alex, I certainly want to hear your view, I know you sat there for nearly an hour, sorry, is you are on a military base. Your every movement is controlled by soldiers. And that regime is brought into the courtroom. It is a military, they're a military police officer, but they're still a soldier who reads out that, script every day to us. takes your devices, doesn't let you leave the room without escort, because you're on a military base. And to have something like that occur with him falling asleep, with the curtain, the email that Carol's just sent me is that there's a French-Canadian criminal defense lawyer from Montreal there who's been confined to, possibly being confined to quarters. She's been banned from the courtroom. It seems to be something to do with mistakenly having a phone in her bag at the checkpoint. So we'll have to hear what happens from that. Maybe Carol will send us an update. You know, this is so far removed from the usual court experience. What was your impression, Alex, of just this process to begin with? And then I'm going to broaden it out to this question about open justice. So if you want to move on to that and the transparency of it, please do.
Yeah, I've enjoyed listening to everyone. I think that my impressions were mostly, yeah, it's a juxtaposition of the outrage of what you're seeing. I thought Zim made a good point about how we all stood or stopped for the national anthem, and then what you saw in front of you. To Colleen's point about sort of the veil separating people, the only place that I can think of where that happens in the American criminal legal system elsewhere is when people come to view an execution, is that they have a curtain and that divides people on either side of it, for people who are with the victim's family and people who are with the defense. And not to be overwrought or dramatic, but that in many ways felt like what I was witnessing, in that there was a really bizarre and alive question that animated the entire procedure, which is why even bother, in that the prosecution is committed to the view that, as Zimran mentioned, in terms of the jurisdictional hook for the court over why it purports to have jurisdiction, or does frankly have jurisdiction over the accused, is that because they are enemy combatants, there's no set of circumstances in which they'll be released. And the prosecution states, even if they were to be adjudicated innocent at this proceeding, they still would be enemy belligerents and they still wouldn't be released. So the question becomes, why is it that we continuously put forth the effort to hold these hearings? And I think that ambiguity permeates at every level of Guantanamo Bay. There's no person, I believe, maybe Carol, but she's not inside the regime, that has a clear sense of purpose about why it is the case that these proceedings are happening as such. And it calcifies into bizarre rituals. Mine, that I'll add onto the pile, is that every morning the defendants are formally given the right to attend their trial. And at least as of when we were there, they were on some form of strike. They didn't come and participate in the trial because they were protesting their conditions of confinement. And again, someone on this island believes that it would be prejudicial to American national security to reveal even the name of the guard that the individual interacts with every single day to the defense counsel. So this person who has spoken to and presumably interacts with these detainees on a daily basis, has never shared their name with them, then comes into the court. And again, I think Colleen and Jay's point about sort of the comfort that people come to find with the absurdity of it is that now the names that they offer as their code names are sort of jokey. It's a very solemn proceeding, but there will be names like Bandit or Scout or something like that. And that's how they'll be referred to in the entirety of the proceedings. And that's just one slice of life that you get throughout the entire sort of kaleidoscope of the island that is no coherent posture towards or commitment towards what it is that we're doing here. And the defense is just as invested in this posture, in that they, of course, won't have their clients come, but there's an ongoing dispute as to whether or not the clients themselves are able to come into closed session. And also think about that. I think it's important to notice that for the week that we were there were 5 days of trial. The court 9 to 5 operated even into the night. we were only there for 2.5 days, and the remainder of it was a court that the defendants formally can't attend, the defense attorneys can't formally tell us about, sometimes there are ex parte meetings that are just routinized that the defense counsel won't go to, but the defense counsel will warn the judge in advance what their defense strategy is, so that the judge can then be their advocate in between interacting with the government in private, not even with an extant record created. And so when that occurs, the defense will then formally read onto the record that their clients want to come to the closed session. So it's this fascinating sort of just only in Gitmo sort of bizarre situation where at the same time the defendant will refuse to come into the courtroom to protest conditions of confinement, yet as soon as it becomes a closed session, the defendant, of course, would immediately then want to be present and end their dispute. And that's just one of many of these bizarre things that add upon themselves to no real cohesive or coherent posture towards fundamental commitments like due process.
Yeah, absolutely. And there's, I know we've been using the word sort of bizarre about the process, but to me there's a real cruelty to it as well, in terms of, you know, treatment of the bereaved victims' families there who are not getting to any sort of process with any kind of reasonable period of time, but also these ridiculous things like the curtain, you know, not having their wishes respected, but this to and fro transportation thing as well of defendants from prison to the courtroom, even has a cruelty to it. In the El Nashiri case, what struck me about that in particular was, you know, that being transported in what is a very confined space, a small box effectively in the van, every day, is another form of torture, because he spent a lot of time as one of the torture techniques for him in a tiny confined space. And so to be put through that process immediately before you then have to go to trial, well, pre-trial proceedings, but you need to be able to listen and effectively participate in those proceedings when your experience of torture has just been triggered. There are no accommodations here, it seems, for the needs of the participants in this trial, who it should be about on either side. It's a comment from me. The next question I wanted to just take you to before we take questions from the audience, I can some are coming in. So if you do have any, please do feel free to pop them into the Q&A, and we'll have a look at them shortly. Is about the openness and transparency of the proceedings. You've all touched upon certain elements of how you came to be there as observers to this in Guantanamo. Do you feel that it is sufficiently transparent from an observer perspective? And what changes would you want to see about making, if it's not, this process more open and more transparent?
I can maybe start that one off in that I would resist slightly the idea that when you're on base, you're escorted by military personnel 24/7. In that we had to the point of it's always shifting. We had a very new sort of minder staff, and it is reminiscent of going to a country and having sort of a minder follow you around. But structurally, it's the case that it really only is one contractor for about 5 or 6 people. And our week, we were fortunate in that I think that a lot of us had the same posture of being very inquisitive and wanting to investigate. And so we were able to sort of get ourselves slightly into trouble a few times, but attempts to evade the program that was put out for us. There's a bike shop on the island. You can just rent a bike and just pretty unrestrictedly go around, go to Camp X-Ray. I went as far as I possibly could to where the detainees were held and biked around the perimeter for a few hours. Again, but so formally, you're unrestricted in the way that perhaps the journalists are, and that they do have dedicated multiple member staff that will stay around them and constrict them. I don't know that that's necessarily to the program's credit, much less the program's sort of inability and the fact that we're treated by an afterthought. In that, I'll never forget, one of the requests that we made was to see where the detainees would stay if they, sort of in the subjunctive, were to have decided to have come to court and were to have be held in confinement between court sessions. And Scott Searwold, he was our representative of the military commissions the entire week in the NGO tent, told us, and this is a direct quote, I wrote it down, I was so shocked. He told us that we wouldn't be able to see that because we might take it out of proportion of how other federal treatment facilities or federal confinement facilities are. And so the literal official on the record proffered explanation that the United States government gave us in denying our access to where detainees were confined was that the conditions of confinement would be ones that we would report back on. And that was outrageous. But so if he were in charge, or if I think if he had clear in view exactly what it was we did that week, I don't think he would be A, happy, or B, on board with it and would have taken more direct efforts to curtail our sort of freedom of movement. Yet, as a descriptive statement about how the Observer program currently operates, it's pretty much like the Wild West in that many things like 9/11, things have just disaggregated, atrophied, people have taking less and less of an interest in it. I'm sure it will get, when more formal movement comes, I'm sure it will get more built up. But those are my impressions of the current state of play.
If I could just add to Alex's observation to once again point out the arbitrariness. So Alex, the incident you're talking about happened in 2024, this year. Until at least 2020, before COVID shut things down, it was a regular weekly part of the NGO tour to go look at those spaces where a defendant would be held during a lunch break, or if they wanted to take a break from court. That was a regular part of what NGOs saw every week. So why that was okay up until 2020 and then all of a sudden in 2024, again, it speaks to the arbitrariness of so much that happens at Guantanamo. And just one thought about, if I may, about transparency. Our organization from 2012 has advocated that these proceedings should be on C-SPAN. That is a television channel here in the United States that has Congress, and whatnot. It should be on C-SPAN so that any person around the world could be watching the proceedings. 9/11 was probably, if not the most public event in human history, certainly one of the top three. Such a public event should have a very, very public accountability and response, I believe, and our organization believes. So why it's not on C-SPAN, and that was litigated early on in 2012, but that's a loss for everyone.
Was there a reason as to why that wasn't deemed appropriate?
Initially, there was concerns that there would be unrest. I mean, this is so long ago. This is my memory of how it was presented when the arguments were actually argued in court, that there'd be political unrest. Yeah,
Right.
That's that. But it was, the judge.
It sounds like an excellent idea to me. I mean, if you can't take the proceedings off the island into, the domestic jurisdiction to have proper due process, you should at least be able to take those the camera shot of those proceedings and broadcast it out, especially because they've demonstrated that can be done without security concern. Zimran, do you have anything to add on that question or topic before I turn to the questions from the audience?
So just on that transparency point, I definitely endorse what Colleen said about C-SPAN. I think that was my first thought when I realized how the proceedings are set up, and there's a feed to an external viewing facility as well. Although Colleen said it's no longer taken up anymore, but if these proceedings were viewed on that a channel, I think that would be a very basic first step. Also, if observers like me, Alex and Colleen, if we have information given to us in advance of us landing at the base, just of the very basics of what's going to happen, it would save us trying to jigsaw information together once we're already there. And we did try to jigsaw a lot together and had limited success, because we were told on first day, well, you can ask any question you want, and we'll be here to try and get you the information and get it authorized. But in reality, anything that me and Alex put together, most of the time it was knocked back without any answer at all. And many of our requests were just very basic requests for information. I remember even taking a photograph next to a sign that said Camp Justice. That had to be, I think it took a couple of days for somebody to approve that, and only one person was going to take the photo, and it would be 2 photographs taken, and that's it. So just, again, basic information was hard to obtain and get authorization for. I remember the individual that Alex mentioned, Scott, one of the observers asked him a question, and it was very uncontroversial in terms of the information being requested. And the official said, sorry, you can't have that information because of a protocol that's in place. So the observer asked, well, can I see a copy of the protocol, please? And the response was, well, it's the protocol in my head based on my experience. So that's the kind of response you were sometimes met with.
Yeah. I think just to give us one more example and question on this theme then from our attendees, Lauren Ledgery has helpfully joined us. Thank you, Lauren, for being here. She's also attended for the Association of Defence Counsel for International Courts and Tribunals about a week or 2 before you were there, and I know Tom Dyke is there right now from the same organisation. She says she was struck by how Commission staff advised her not to speak to the media, as well as their repeated efforts to avoid interaction between NGO observers and the media. It's really interesting. I did not have that experience because I was able to speak to Carol freely. But again, I didn't ask for permission to do that. So I don't know if I had done, whether that would have been denied. But have any of you had that sort of experience? I'm just going to put my light on, by the way, because I'm becoming more and more ghostly as the hours fade here. Zimran, do you want to take that one first?
I was going to say, I think Alex would be quite well placed to answer that, and he managed to spend some time with Carol Rosenberg, and how that might have gone down with the chaperones around us.
Yeah, that was fun. There's this question on Guantanamo as to whether or not you're in your own head or whether or not you really are playing sort of spy v spy. And so I reached out to Carol before we made it onto the island, and we sort of exchanged messages and then found a way to exchange messages in a more secure setting. And so we told our minder, I don't remember what exactly we told our minder that we were doing, but we were doing something at the marina. And then we had sort of surreptitiously arranged with Carol for her to come down there. And we talked to her for about an hour and a half or so. And very pointedly at that time, materialized the sort of deputy in charge of security at the base, not the chief person, but the person who reports to him, who was just at the marina and very clearly did not have a purpose of being there and was just literally ominously smoking through a few cigarettes. Yet, again, the central theme of Guantanamo Bay is the theme of ambiguity, in that Colleen has pre-existing relationships with all of the journalist cadre here. And also for Colleen, I want to shout out, if any of you have heard of the recent serial series that was done. She's actually an entire episode of it. Colleen Carroll, there's some of the people that I consider legitimate American heroes, and I really do mean it. And so Colleen was then able to ask, perhaps that she's much more experienced at this than me and Zimran, in that we played our little spy v spy, used the secure messaging app, went to Carol, and were rumbled within maybe 5 to 10 minutes. Colleen just asked the driver to be taken to speak with the media, and then spoke with them while we were there for about an hour without incident. So two competing approaches, and I wonder what Colleen's thoughts would be.
I'm going to sound like a broken record. I think it's so arbitrary. The media and the NGOs used to stay in tents that were right next to each other. So every night there'd be an opportunity to hang out at picnic benches together. It's so arbitrary with each changing guard force and each changing chain of command. It's that, as we all know, arbitrariness leads to really bad problems and that become insidious and really deep. So to not have very specific rules or protocols that change or protocols that are in someone's head, that's not fair. That's not right. And why should NGOs be prohibited from speaking to the media? That's our job, is there to observe, and observing, one would think part of that is asking questions and talking to others about what they're seeing and hearing. So I would encourage, if you have an opportunity there.
Oh, we've lost your sound.
Better to do something and ask for forgiveness rather than ask permission.
Sure. And I mean, look, we're all going to get off the island and speak freely like we are now. So what's the point in trying to stifle it when we're there? Really, it seems bizarre, and it suggests that these people don't really understand the purpose of having observers there. Chris Cravenda has said on the chat, it all seems to be a bit of a ruse. I mean, there's a risk, isn't there? This is something Carol raised to me this morning. There's a risk of having observers there to give the veneer of an open and fair process, but then to limit it really getting to the bottom of what's happening, or indeed listening to anything that process says. Colleen, you given the example there of asking for a simple and logical solution to the transparency problem, and that's just been shot down. We asked to see any prison facilities, that was denied. So yeah, it does seem like there's much more that could be done in terms of openness. Talking about prisons, Stephen's asked a question here about Stephen Galavat-Andrea. So Steve, he's a colleague in Chambers. You might want to know his surname. Barrister in my chambers. Would you be able to elaborate briefly on detention conditions, and passing on his sincere thanks for the occasion? I mean, the detention conditions, none of us have seen them because it's been denied on all occasions. I've asked Tom Dyke by email this morning if he can try and ask the same question in another way to see if he can get anything further. As we've suggested, the UN Special Rapporteur report on it is very detailed. She did get in to see it. I referenced that in my report from last year. summarize some of the details. What we know from her report is the core concern when people have experienced torture for on and off for 4 years, both physical and mental torture, that obviously leaves severe outcomes for the person, both physical and mental. And the real concern is that the treatment is inadequate for both of those needs amongst the detainees who remain. Not all of them are on trial. Detainees there not on trial but have not been released and won't be. Obviously, these people don't have access to family or friends. There are no visits. In that sense, it is isolated. They have, over years, been allowed access to each other, and they're allowed to cook meals together on occasion. Certain religious rights are respected, but there are fundamental problems with it in comparison to other federal prisons or prisons here. So I'd recommend to go and have a look at that report. It's referenced in my Al-Nashiri report, if anyone wants to get to it that way, which is on the BHRC website along with Zimran's. A couple of other questions here about the process in terms of taking part in trial observations. I think I'm supposed to answer these live. Sorry, I never understand what this means. So I'm going to click the buttons and see what happens. I don't know if that means everyone else can see it or not. Other opportunities to follow proceedings. Well, for BHRC, potentially, we're always looking at when we will go again. And I know, Colleen, you said there's an importance of having observers there who are professionally doing their job as well, reporting on that. We know there's quite a few observers who go but don't really do anything with that experience. So BHRC will be looking at going again over the next year, and there are other organisations which send people as well. I think the next question is related to this. Would it be possible to have further references as to material to read concerning Guantanamo trials? We reference quite a bit of that in our reports. Just Security has a really great blog which keeps up to date what's happening. Carol Rosenberg's reporting in New York Times is excellent on this. Anyone else got suggestions for where to be looking at for material about Guantanamo? I mean, the actual military courts website has the docket for each case. It's incredibly frustrating to work through because there's 12 years of documents. A lot of them have a security stamp on them. So you're not going to get anything recent there because it's all going through a security clearance process, but it gives you a certain sense of what's happening at least. Any other recommendations?
I'll reiterate the recommendation for Serial, which is an American radio podcast series. And again, you'll hear more from Colleen. It was really excellent and well done.
Thanks, Alex.
Yeah.
I would also recommend Law Dragon. There is a reporter, John Ryan, who attends all the hearings, and he kind of gives the long view. They're longer pieces than Carol's, which are in the New York Times. And for people who want to do a deep dive on any of the hearings when they're in action, you can, on X or formerly Twitter, you can follow Gitmo Watch, because they have someone who's reporting kind of as things are happening. So that's another, if you're in for a deep dive.
That's really helpful, thank you. And Lauren says that our Bellucci defense team has its own X account as well. So that, I guess, will give you
That's
more.
That's Gitmo Watch.
Oh, is that the same thing?
Yeah.
I see. I was going to say that might give you more of a defense perspective, but sounds like it's worth having a look at. Couple of other things in the chat. Do you have the option to push back on anything you're told as an observer? I'm not necessarily sure what the context to that might be. Any thoughts on that one?
I think our group was pretty on the front lines of that, in that I noticed you mentioned in my introduction that I spent a brief amount of time in England. I know there's a discomfort in like making other people uncomfortable in sort of the Gitmo is a piece of the Gitmo NGO experience right now is a piece of social engineering that is designed to trick and confuse you into thinking that you are on another Caribbean vacation. It is fused with alcohol. You can literally go out, like, it is no exaggeration to say that you can go on a boat and just go and see beautiful scenery in your swim shorts. There is a sort of infamous for our group every Thursday. There is a weekly Mongolian barbecue that is just an event on the island. You will see the judge there in a Hawaiian t-shirt. In that, it is designed for you to just take the inertia. They have a very clear plan for you. They have activities planned every day of the out-of-court session. There's a lighthouse you can go and visit. Yet, you can always say no to that. And I think that our group did a fairly steadfast and good job of saying no to that, of being attentive, of being focused on work, and attempting to actually hold the government to account. It'll be Sisyphean if you go there. It's not going to be satisfying. Victories will be measured in close to nothing, sending a very strongly worded letter, which will mostly just be cathartic, but it is possible for you to go in and resist the official narrative and program. At least that was my experience.
Yeah, and I think that can be difficult because obviously these people are there to assist you whilst you're on the island. So, you know, you've got to have a certain relationship with them as well, haven't you? In order to get anything done that you want to try and achieve. And there's an important balance as to how you manage that. I mean, the follow-up questions from Joanna here are around if there's anything you see uncomfortable during an observation, can you escalate it? I mean, my answer to that would be, from my impression, well, it depends what it is, but if it's, you know, something you're observing in the courtroom, no, because you're there to observe and document. And of course, as defense and prosecution teams there, you're observing both of them and what both teams are doing in the context of assessing whether this is a fair process or not. What we can't really do is interfere in that process. We have no jurisdiction to do so. We're also behind glass, but it's not the role of an observer to stand up and try to object during a live process, no matter how much we might want to. Unfortunately, which can be frustrating, but I have seen far worse trial processes than this in other parts of the world, I have to say. Colleen, you were going to intervene there.
I do want to add, so I appreciate the question because there are things that happen outside the hearings themselves, and really odd, irregular, several things have happened over the course of 12 years. Yes, there is recourse. The first thing you should do is notify the person who coordinates your NGO. So I'm the coordinator for Peaceful Tomorrows. If something happens on island that is super egregious, it needs to be addressed with your escort. It can escalate from the escort up to the person who's the head of the escorts. And if it's still not satisfactory, there are people at the Pentagon who then get involved, who their job is above the coordinator of the escorts. It's really helpful to be there with other NGOs, many of whom are often lawyers. So there have been incidences where the NGOs were told that they were not allowed to discuss the case outside of the NGO tent. And that's just ridiculous. So there was lawyers, you know, who had done work all around the world who escalated that, and within 2 hours that was realized for what it was, just someone's arbitrary rule that they made up. So there are ways to escalate these issues, and also to join with your other NGO observers, because there's power in numbers, and people saying things together can change things rapidly, or sometimes these things happen after the hearings are over and it gets dealt with afterwards.
Well, it's good to hear that there is that line of communication that can at least make changes for the observer experience. I have to say I didn't have that kind of problem myself whilst I was there. Maybe I was just a bit too wheeler-dealer in the way I operated. I don't know. I think that's all of the questions really covered, and I'm conscious of the time. Unless there's anything else, are there any final thoughts from the three of you that you haven't covered so far that you might want to just express to sum this up?
Jodie, just very briefly, if I can just say thank you to you for chairing, and thank you for Colleen and Alex for participating, and obviously James, who's had to leave us to participate in today's hearing. It's a really strange experience to go through in lots of different ways, and there are many things that we're not able to talk about in this session for lots of reasons. But for me, I think Colleen and Alex kept my sanity. They became very, very good friends. Colleen is very experienced and has been doing this for many years. For me, like her tent was next to mine. So before sundown every night, we just sort of sit down and debrief about the day's events and what we'd seen, how we felt about them, what sorts of questions we might ask the next day. And I think that was completely invaluable. And we can talk about how things can be turned into sort of human rights tourism, and there can be lots of things put on to distract you. Alex was absolutely brilliant at dealing with that. You know, he pursued every line of inquiry with doggedness, whether it meant getting on his mountain bike and going off on an expedition of his own, or sending lots of follow-up emails and planning meetings of how we were going to collectively use our resources and our efforts all to go into the same query and have the same query answered. And you know, that's the way. It's a big responsibility to be a trial observer in this sort of situation, and he exemplified how we should take that responsibility on. I'm really, really grateful for the time I spent with both of these individuals.
Thank you so much. Alex, Colleen, anything else? You don't need to say anything else. I mean, we've heard your views very clearly. So just
gratitude.
Thank you. To finally say then, on our behalf, the Zimran's report is now on our website. Do please go there and have a look at it. You should have had an email, or it'll be coming through shortly to direct you to that. But it should be prominently placed there, and you'll be able to find it if you follow us on any of your socials as well. We will send that report out far and wide to the press and to our contacts, and do as much as we can to raise awareness about this issue. We have obviously said in each of our reports now that we think that the facility should be closed. This is a trial that should be taking place with due process of US law. And if that's not possible, then it should stop, because it doesn't seem, from what we have seen on our 3 occasions, and from everything we've heard, from not least the speakers here, that this process is going to result in a satisfactory conclusion for the victims of 9/11, or indeed in the Yemeni bombings, the USS Cole bombings, which al-Nashiri is involved in the trial of. So we'll continue to make those observations and raise awareness as much as we can. And if anyone else would like to be involved in BHRC's work, please do go to our website and join us in that endeavour. But thank you once again to our speakers and James, who's left us, and thank you to everyone who stayed to hear the webinar this evening.